Welcome to this part of our joint webinar series between King's College London and George Washington University Law School. Today we'll be discussing developments in defense procurement with a special focus on developments in Europe. I'm very glad to say that we have registrants today from 46 countries spanning 5 continents. Thank you all very much for joining us. A special welcome to our colleagues from Ukraine who are joining us today. Just a point of apology up front. Throughout today's program, you're going to see defense spelled 2 different ways, once with S and with C. I apologize for that. Noah Webster was an American who wrote a dictionary in 1828, and it was a nationalist effort to try to differentiate the United States from Great Britain, and he spelled many words differently, and that's why American and British spelling differ, because of that dictionary dating back to 1828. So again, I apologize for the difference in spellings. Today's program, as I said, focuses on European procurement, defense procurement issues. We're going to have another webinar on November 9th discussing the U.S. perspective, and you should feel free to sign up for that on publicprocurementinternational.com. Again, that's publicprocurementinternational.com. The recordings and materials from today are going to be available the recording is going to be available later today at publicprocurementinternational.com. It'll also be available on the GW Law Government Procurement Law Program, our YouTube page, our special YouTube page. So you'll be able to see the recording in both places. During the course of today's presentation, if you could please use the chat function and not the Q&A function. The chat function is a way for us to exchange information. It becomes part of the record of today's program. So please use the chat function, and the panelists will be responding to questions as they come up. Again, just to be clear on this, all panelist statements are in their personal capacity. And again, we very much welcome questions from the audience, and the panelists are prepared to respond to those in the chat. The purpose of today's program is to help build a bridge between the European and U.S. procurement law communities regarding the vital question of defense procurement. Our webinar on November 9, as I said, will offer U.S. perspectives. Today's panel is ideally suited to present European perspectives. Co-moderator Michael Bauscher is King's Counsel at Monkton Chambers and visiting professor at King's College London. He is one of the United Kingdom's foremost public procurement lawyers and regularly represents agencies and contractors in some of the most important cases in the United Kingdom and the Republic of Ireland. He leads a master's program in public procurement law at King's College London and regularly co-hosts these joint programs with GW Law. Charlotte Brulid leads DLA Piper's procurement group in Sweden. Charlotte assists clients in public procurement at all stages and has broad experience in public procurement in all phases, both nationally and internationally. Charlotte has a background in supervision of public procurement at the Swedish Competition Authority and served as senior legal counsel to Swedish Defense Material Administration. We have an article by Charlotte on security-related procurement in Sweden. It's on the program page at publicprocurementinternational.com. Luke Butler is an associate professor in law, director of the executive program in public procurement law and policy, and a member of the public procurement research group at the University of Nottingham. He's a commercial lawyer with a specialty in government contracting. He's joint editor alongside its founder, Professor Sue Arrowsmith of the Public Procurement Law Review, a member of the European Procurement Law Group, and a member of the Procurement Lawyers Association in the United Kingdom. He is currently a non-practicing barrister. His academic research has a heavy focus on defense procurement, and he was author of Transatlantic Defense Procurement, EU and US Defense Procurement Regulation in the Transatlantic Defense Market, which was published by Cambridge University Press and is also featured on the program page if you'd like to get a copy of that. Tomasz Dorowski is an attorney in law and partner at DZP in Warsaw, and he leads its defense team. Tomasz advises clients on transactions involving the sale of weapons or dual-use products and on projects involving the establishment of industrial cooperation in the defense sector. Pascal Friton is a specialist lawyer for public procurement law, a Fachanwalt for Vergaberecht, and an expert in international trade law. His public procurement law practice covers advice on both contracting authorities and bidders, and particularly in the IT, defense and security, infrastructure, energy, and healthcare sectors. Pascal is regularly ranked as one of the leading public procurement lawyers in Germany. He's advised various defense and security companies in procurement procedures and represented them in review proceedings, such as shipyards in the procurement of MKS 180 frigates and K-130 corvettes for the German Navy, and a company in the review proceedings for assault weapons for the German Armed Forces. Again, just a reminder, if you'd like to join the November 9th program, please feel free to do so. Public Procurement International. Larry Bowles, who's one of the American panelists for that session, is joining us today as well. And you should feel free to ask questions of Larry. You should go. Again, he's a specialist in offset matters. So with that, I'll turn it over to my co-moderator, Michael Boucher.
Thank you very much indeed, Chris. Good afternoon, good morning, wherever you are. It's a great honor and pleasure for me to be able to co-host this event today. We've had so many years of great work together in many fields with GW, and it's been great that we've been able to translate so much of that into the virtual space in the last couple of years. I do hope that we can get a bit more of that in real life as well going forward, but this is such an important topic, and we're very glad to have this complementary pair of sessions on defence procurement going forward. It's such an obvious and important topic to consider, because defence procurement not only is important in itself, plainly undergoing something of a revolution for all sorts of obvious reasons, but also defence procurement is historically at least a driver for many of the complex ideas that then filter out into other parts of public procurement in terms of the way in which costs are managed, performance is managed. So many of the problems and challenges and new thinking around procurement often starts in procurement, in defence procurement. There is, as Chris has said, there's a wealth of material referenced on the website for today. I won't try and talk you through all of it. There are so much of that material makes the same point in different ways. This is perhaps just what one just illustrates one of many metrics, which will shows one the level of European expenditure. Plainly, we're dealing with a period as a result of events in Ukraine, but also reactions to other circumstances around the world, preparedness for how things may develop in the Pacific. We're going through a period of where not only is the scale of defence procurement having to increase dramatically to reflect not only increased demand, but also the need to replenish stocks as a result of increased demand, but also the nature of the focus of what's being procured is changing, and the ability of our systems to react to that, and for us to be able to fit that within the overall budgetary constraints that are imposed in any normal situation, but of course certainly in Europe are very much a consequence of the very security situation which we face. So there's all sorts of complex issues, budgetary, technical, legal, which we need to address. We're looking forward to hearing how some European states have started to respond to some of the challenges in moving their defence procurement law forward over the rest of the day. I won't say any more. Let's get started. Chris. Oh, there we are. Yeah.
Thank you very much. Thank you very much, Michael. I'm going to pass it over now to Charlotte from DLA Piper's Stockholm office. Thank you very much, Charlotte, for joining us.
Thank you very much for inviting me to participate in this very interesting and seminar and webinar. I haven't participated before in this context, but I'm very much looking forward to a discussion concerning these very highly relevant topics. And as we have all experienced, the defense market is very special and closely connected with national security, and therefore central for national sovereignty to take it to that level. Bearing in mind the common efforts in the EU, such as the progressive framing of a common union defense policy and common defense, as well as the writing in the treaty of the member states that they should undertake progressively to improve their military capabilities. And at the same time, bearing in mind that what's raised as the most important in the national Swedish strategy for defense is national interests. So the answer to the potential question, why is the Swedish perspective interesting? The answer must be that we are one of the 27 member states that now, in the progress which we see in the EU, is an important party. And I mean, at the end of the line, if we would take a decision concerning cooperation on another level, we all need to be at the same line, so to speak. So therefore, I find, from my perspective, who is a Swede, that the Swedish perspective is very important and relevant in all of this discussion. I will do a short presentation, and I will focus on the Swedish perspective in general, and also include the NATO application and the ongoing work within the EU with the suggested EDIRPA, European Defence Industry Reinforcement through Common Procurement Act. And more than this, I will mention something about the challenge to combine the necessary innovation in defence and the lack of time and resources. To mention something about the background in Sweden, the characteristics of the defence market are obvious, where we have the regulations concerning special regulations in defence, including export licenses, and trying to balance it towards commercial values. And when discussing the Swedish perspective and defence procurement, the historic perspective also needs to be mentioned. Because looking back at the Swedish history, innovation of defense material is very strong and a very strong and important force. And going back to times after the Second World War, Sweden initiated different projects that involved cooperation between the industry, engineering sector, and the governmental authorities. And the cooperation was not publicly procured, however, very fruitful. And do one dare to say that today, but however, it has been lifted as part of a very important era where the Defense Material Administration and Volvo and Saab developed cars and airplanes, and sometimes mentioned in the context that the Swedish prosperity was built on these types of cooperations and the export that it resulted. However, in times of peace, Swedish politicians has found it particularly difficult to justify high costs for defense. So since in a series of decisions from the 1980s and onwards, the Swedish defense has been sort of disarmed, obviously disarmed. So thereafter, and in 2015, different Swedish decisions have been taken to rebuild the Swedish defense and to support the defense financially with stronger defense budgets. And as it is today, we can't discuss any European defense without mentioning the new security situation. Sweden has been in peace for 200 years, but the Russian attack against Ukraine show that we do need stronger cooperation with greater operational forces, and now applying for a NATO membership. In Sweden, we are moving from a division from civil development and defense development. And to just pick up what you said, Michael, as you said, the development has been strong in the defense sector. But nowadays we see in Sweden that the civil sector is very important, and that we need to start being able to use all equipment in times of crisis and war. So that's part of what we do in Sweden, trying to figure out how to use civil equipment and how to actually be able to use it in also times of crisis. A governmental investigation has suggested a new strategy for defense material. And in that, it is clear that planning and management must contribute to the needs, and that the state must act collectively and consistently to influence and utilize defense-related cooperation within the EU, and that the state should contribute to Swedish defense companies' opportunities to maintain and develop their competitiveness, More than that, the state should promote and support exports that contribute to the material supply. By that saying, export is also part of the political arena when deciding how to defend Sweden. And with that, I can go to the next picture. So as I mentioned, the availability of the private sector's capacity in times of crisis and war with regard to such important development in IT structures and other structures is an important question from the Swedish perspective. And how to control and finance technological innovations is also an important question. We have within the national structure also decided that some parts of the Swedish structure is now of a national security interest, and that is the fighter aircraft, underwater and command, control and surveillance of information domain. By that said, the exception in Article 346 in the TFEU can be used for those equipments. So that is part of the Swedish perspective today. More than this, the balance between international cooperation, interoperability, and national capacity is not easy. More than this, the EU interest and mutual development versus the subsidiarity principle. With that, I want to come into the suggested EDIRPA. The new instrument, which I think might be mentioned later as well, but there is a new instrument suggested from the EU, and the requirements are that the cooperation shall be between at least 3 member states in the EU, and it shall concern purchase of the most urgent and critical defense products. And the contracts that are performed according to the new instrument may not be subject to any control limitations from third country, non-associated third countries. And for this, 500 million euros will be set off. And Swedish view is important here. Sweden is not at all only positive to the suggestion, because it is said that competition is a very important factor in the development of a Swedish defense. And in the suggestion, it's not all clear how it shall be applied and what parts are most important, and how the choice between different projects will be done. And more than this, it's very important from a Swedish perspective that the cooperation with non-EU countries, such as the US and the UK, which may be particularly interesting today, are very important parts of our defense structure. It's also so, from my personal view, working within the defense sector previously, that the time for this project is 2023 and 2024, which is quite a short time to be able to actually achieve any big or important collaborative projects, and also aiming at innovative projects, as we probably all have some experience of, will take a lot longer time than that, particularly between countries. More than that, of course, research and development is important. And concerning the Swedish application to Nato, it's a very quick process. As I mentioned, Sweden has been in peace for 200 years, and we have been non-bound to any organization of that type. However, since Ukraine was attacked, we have applied for membership, and we are now at the state where we are invitee, and we are raising our budget for defense to 2%. And in this part, I also want to lift something that I see as a challenge, and that is we get a lot of money to the defense sector, but we do have a short period of time. And in that discussion, Sweden has a restrictive use of the exception according to the TFEU. And with a restrictive view of that, public procurement will take quite a long time. So how will the money be spent in a short time? I think that is one of the challenges that Sweden stands before. And I also would like to lift the EU directive in public procurement in defense and security, because there you can also find some of the exemptions that probably are suggested in the a DIRPA suggestion. And with that, I want to give the word to the next speaker. Thank you.
Thanks very much, Charlotte. Charlotte, before we go on, can I ask just a quick question about Sweden and about your history? This is an extraordinary history. As you pointed out, Sweden has not been at war for 200 years. It's a remarkable history compared to, let's say, the United States, which has experienced many wars over its history. If Sweden were to go into war, what would be the popular reaction in Sweden? What would be the reaction to that kind of historical shift?
Do you mean if we were under attack or if we participate in the NATO? If we were under attack? Well, we are working. That is a very good question. Thank you, because we are working towards an awareness of that situation. The society on both the municipalities are very strong in the Swedish arena, and we are working from both the municipalities and from the governmental side to raise people's awareness. So what's happening in real terms is that we're getting actually papers to our homes in our post boxes where we get instructions on what to do, because there is no such awareness, if that's the answer to your question.
Yeah, it's for Americans, it's very different in the United States because of our geographic location. There's a direct involvement of the industrial base in war preparations, and through the Defense Production Act, that's a legal instrument for bringing in the industrial base. But there's very little involvement of the civilian population directly in war preparations.
And we are shifting governments also, to go into it a bit deeper. We are shifting governments at the moment, and one of the defense ministers that were aimed yesterday is just within the civil defense sector. So we are working with that and preparing overall in the society how to be prepared if we get under attack. Because as I said, we have been downshifting for very many years, which creates quite a lot of problems when it comes to all sorts of defense material and also the society's preparedness. And things like rooms where we can hide are no longer used, for instance.
Thank you very much. Pass it on to Tomasz.
Thank you. First of all, thank you for inviting me to join this webinar. I will be presenting the defense procurement aspects from the Central Europe perspective, of course, particularly focusing on Polish perspective, which is important because Poland is the largest market in the Central Europe and also very heavily involved in the indirectly, of course, in the war supporting Ukraine. And we all need to keep in mind certain important facts about Polish industry, Polish defense sector, but also other, let's say, Central Europe defense sectors. First of all, we've got a very strong state-controlled defense industry, which is, or at least has been so far focused on supplying Polish army. And the same in Romania, the same in other countries in this part of the world. We've got another important thing to remember is that two dangerous neighbors are just 300 kilometers from Warsaw, one to the north, the other to the east. And that makes us feel very engaged in what's happening in Ukraine. Yet another thing to remember are the strong political ties with the US and some kind of hesitation when we talk about the defense matters with the European Union. I will illustrate this later on with some examples. And one other universal thing to remember is that the defense sector and procurement in defense sector relates to a wide range of purchases. It's not just military equipment, it's really wide range of goods, products and services that the military is buying. And that translates into various ways of procuring those items, because the practice shows that that one way is applied to buy items like F-35s, and the other ways are applied to actually buy some basic materials such as petrol. But I will come back to this later on. The first reaction in Poland to the war was actually to significantly increase the military spendings. Next year, we will be spending 3% of our GDP on the defense needs. This year, this will be 2.4% of GDP. And that means that between 22 and 23, our defense budget will increase from $12 billion to more or less $19 billion. That's a lot. But that's also a problem for Polish military and Polish procurement agency, because they need to know how to spend the money. It's not that easy. The same with other countries from this part of the world. For example, again, Romania is to increase the defense budget to 2.5%. Baltic states are already over 2%. Generally speaking, this part of the world is spending more. And it's not just the reaction to 24th February war, it's the reaction to actually what's been happening over the last 8 years in this part of the world. I will say a few words on the contract award procedures from the Polish perspective. First of all, the largest projects are contracted via G2G contracts. Let me use an example of the acquisition of Abrams tanks or F-35 acquisition. Polish government uses this way to buy military equipment from the US government mainly. And of course, we are all aware of the Commission notice of 2016, providing some guidance on the award of this kind of contracts in this sector. It's difficult for me to comment on how it is this guidance is applied, because it's confidential information, whether the market analysis that is required or recommended by this guidance is actually being prepared. The pre-procurement advertising, which is recommended in this guidance, is something missing in Poland. So we are just quite skeptical about applying this Commission notice. The other, let's say, ways to procure are just the commercial procurements via let's say, standard public procurement contracts, via, let's say, standard competitive procedures that are rather used for minor projects and supplies. Well, Polish military buys a lot, and that keeps busy both the manufacturers and the procurement agency, but the large projects tend to be procured in different ways, like I said via G2G contracts or via contracts executed based on the essential interest of the state security. There was an attempt to use the in-house contracts, given the fact that the PGZ, which is the state-controlled company, is actually a big player in this market, but so far it's not been actually used. So the other way that is used in practice are the contracts signed without actually any proper procedures, but based on the essential interest of the state security, meaning applying the Article 346 of the Treaty on Functioning of the European Union. The specific thing about Polish procurement system is that this way of contracting is governed by the decisions of the Ministry of Defense. So there is a decision number 9/MOD that defines the procedure for assessing the existence of the essential interest of the state security. And this decision let's say, regulates the contribution of different parties, different players from the military and government in the process of taking a decision whether there is whether the essential interest of the state security exists and allows to procure without applying public procurement regulations. And once such a decision is taken, then under yet another decision, this time 367 of the Ministry of Defense, the procurement agency applies its own procedures, which are different than the ones defined under the public procurement law. There are generally three basic procedures: negotiations with one supplier, negotiations with more than one supplier, and negotiations following the publication of an announcement. This is a very, let's say, unusual way of approaching the things, also because of the fact that there is no appeal mechanism to contest the decisions of the ministry taken during the course of these proceedings. But a vast portion of the military acquisitions are procured exactly this way. Since the beginning of this year, let me jump to another topic. We've got the procurement agency. Well, we've a new procurement agency, which was actually planned for many years as an independent entity, having a separate legal personality from the state treasury, also supervising with the state-controlled part of the defense industry. The agency that was actually established beginning this year is something different. It is just an internal unit of the Ministry of Defense that is combining the competences that so far were dispersed among different units of the Ministry of Defense. That's a very slight progress. The market expected much more, and I'm afraid that the worst treatise of the procurement agency still exists. I mean, it is understaffed. People are not paid well. The quality of their service, unfortunately, is not the one that we would expect, given the budgets we've got. We've got still in force the offset law, but the offset is not, first of all, not obligatory, but also becoming less and less frequent in Poland. Over last 8 years, we had like 3 offset contracts executed in this country, and those most recent acquisitions like Abrams and F-35s went without offset undertakings being imposed. On the other hand, what Polish government is doing is promoting industrial cooperation in some, not all, but in some projects. For example, the projects to build the new frigates for the Polish Navy is done by appointing PGZ, the Polish state-controlled entity, to actually build those frigates. But given the fact that the PGZ has no competence to do it, PGZ launched a kind of quasi-tender to choose partners, and PGZ actually appointed one of them and is now starting the cooperation with this partner, this is Babcock, to build those frigates. I think this model will be repeated in further projects, especially with some projects with the Korean industry that are about to start. What is quite an interesting event that apart from the very strong ties to the US suppliers, now Poland starts to build relations with the Korean defense industry. We are buying the howitzers, the aircrafts from Korean suppliers, quite likely applying the model, the same model as the one that is applied for the, let's say, acquisition or construction of the frigates for the Polish Navy. So, of course, the question appears then: is there any true system in that? I mean, the question is if there is any model that can be understood, and a model applying some clear criteria. And I'm afraid the answer is not. It's sometimes difficult to, given also the lack of transparency, it's sometimes difficult to understand the criteria that the MOD and the procurement agency actually applies. This is quite pessimistic, but this is how the industry sees it. That's to some extent because of the fact that the industry is not used to challenging any decisions from MOD in the courts, and that allows the MOD to do as they think fit. And that's briefly the picture of the Polish defense procurement. Thank you.
Thank you, Tomasz. Just a quick question before we go on. The Americans' understanding of geography is a little bit hazy. When you say that Poland has a very dangerous neighbor to the east, and also, but you said Poland has a very dangerous neighbor to the north. Is that Lithuania?
No, that's Kaliningrad, that's Russia. It's just 300 kilometers from Warsaw. We've got the Russian border. People tend to forget it.
So is that, and as I recall, Kaliningrad is an enclave tucked between Poland and Lithuania. It's a Russian enclave there.
Yes, it's like the unsinkable aircraft carrier. People call it.
An important note for Americans to understand. Thank you. With that, we'll pass on to Luke.
Thank you very much. Good afternoon, everyone. I'm going to talk about developments in the United Kingdom, an interesting case study on post-EU governance. Okay, I'll jump straight to it. I'm going to talk mainly about single sourcing in the UK as the main trend that's developing. So, by way of overview, in the United Kingdom, the main foundation of defence procurement regulation has been the 2009 EU Defence and Security Procurement Directive. That's been transposed in the UK Defence and Security Public Contracts Regulations 2011. And in addition, in 2014, the UK also introduced its own domestic regulation on the pricing of single source defence contracts. Now, following Brexit, the UK published a defence and security industrial strategy. And this is intended to introduce a paradigm shift. How? Well, the UK's membership of the European Union formally justified a policy of global competition by default. That is, we would open our defence contracts to international competition. What will change post-Brexit then? Well, the Ministry of Defence now intends to move towards more strategic partnerships with industry. And this is highly likely to result in more single source, non-competitive awards to UK suppliers and trusted foreign suppliers. Now, in addition to this strategy, in the United Kingdom, there is currently a process of replacing EU public procurement regulation. A new public procurement bill will get rid of the Defence and Security Public Contracts regulations, and going forward, defence and security contracts will be subject to the general rules that apply to the award of all public contracts. But crucially, and to use the government's own terminology, there are significant derogations and carve-outs for defence. Ultimately, much high value and sensitive defence procurement is therefore going to be excluded from the regime. It will be subject to greater flexibility and reduced transparency. For instance, there are many exemptions on grounds of national security, intelligence activities are excluded, government-to-government contracts, so foreign military sales type arrangements of the kind that Tomasz mentioned, excluded. There is broad authorization to make direct awards without competition, and to make contract modifications without publishing the fact. So all of these circumstances are conducive to more single sourcing. Now, as indicated, in addition to this reform, there's a completely unrelated set of regulations that have nothing to do with Brexit or the EU. In 2014, the Defence Reform Act introduced an entirely new legal regime on the pricing of single source defence contracts. Why? Well, since the 1960s, the Ministry of Defence and suppliers were always able to agree prices, to exchange information in respect of prices, and even for the Ministry of Defence to audit the pricing of contracts after they'd been concluded. However, auditing contracts during their lifetime through enforcement of contractual terms proved to be very difficult. Costs and profits therefore continued to escalate. So statutory regulation was introduced in the form of single source contract regulations. And these effectively do the following. Firstly, they introduce a new contract profit formula based on a return on allowable costs. So you can only recover what are called allowable costs. Those are costs which are appropriate, attributable to the contract, and reasonable in the circumstances. In addition to recovery of allowable costs, there is a standard baseline profit rate. This is set annually based on a comparison of rates for other types of contract. This is set following a recommendation of a new regulator called the Single Source Regulations Office. For 2022 to 3, the baseline profit rate is set at 8.31%. And in its latest October consultation, it was confirmed that that new rate will return to pre-COVID-19 market rates. So adjustments were made to accommodate COVID. And the profit rate is also subject to various adjustments, one being an incentive adjustment to reward good performance. Now, in addition to this pricing formula, it also introduced mandatory contract and supplier reports at the start, at the middle, and at the end of a contract. Now, these contract reports are submitted to the Single Source Regulations Office so that it is possible to understand how the price has developed and how estimated and actual costs correspond. Now, some have called the Single Source Regulations Office a toothless regulator. It receives contract reports, although interestingly cannot actually call for the contracts themselves to inspect, but it can issue opinions and determinations where pricing matters are referred to it, and it also conducts periodic reviews of the legislation. Now, why should our international colleagues who've joined us today get acquainted with this curious UK regime? Well, ultimately, the principles that underpin it can be found in the US Federal Acquisition Regulations, and also Australia and Canada have also recently revised their cost and profit principles, taking inspiration from the UK regime, at least in part, albeit not going as far as introducing a statutory regulator. So there's comparative value looking at this regime, but this regime also raises a fundamental policy question, and I'll leave this for you to ponder. Is this emerging UK approach a rare acknowledgement that perhaps we're too dogmatic about the importance of competition in public procurement? Competition certainly isn't the norm in the defence sector, at least in the UK. And so should we be focusing more attention generally on how we properly regulate to address the reality of market failure in lots of these cases? Now, this regime will become increasingly important over time. Why? Well, the procurement bill that is to come into place as an act introduces a number of reforms to the single source contract regulations to increase flexibility and innovation. So it will simplify the profit formula, it's going to reduce contract reporting, and the Ministry of Defence has confirmed in its proposals that these will go ahead. So, for anyone interested in this regime and wants to take a closer look at our UK model, have we got it right? Let us know. What lessons can be learned from this regime for other countries? And what can we learn from you? Please do get in touch with me if this is a topic that interests you. Thank you.
Thank you very much, Luke. Because we're a little short of time, I'm going to pass it on to Pascal.
Yeah, thanks, Chris. Pleasure to be here. Before I dive into the most recent developments here in German defense procurement law, let me just make one point on where we have been in Germany in the last, I would say, 7-8 years or so. A lot of my panelists focused on the fact that there's a vast use of exemptions and not a lot of competition in defense procurement. And actually in Germany, the opposite was true for the last couple of years. We had more and more EU-wide tenders for even hardcore military goods, large battleships, assault weapons, helicopters, and all kinds of other weapons that were actually procured in EU-wide tender procedures. So I guess the development and what the Defense Directive wanted to achieve, it actually did so to a certain extent, I guess in Germany. And what I will talk to you in the remaining part here of our webinar is a little, maybe unnecessary and also troubling, at least in terms of competition and public procurement law, a little troubling development, and that is the German Act on the acceleration of procurement for the federal armed forces in Germany. And this act basically aims at extending the exemptions in the Defense Directive, thereby enabling the Ministry of Defense and its procurement agency to directly award contracts for military goods for the federal armed forces without any competition. As we've heard from my fellow panelists, that is the practice in other member states. My perception in Germany was that we went a different direction, but we're kind of going back there again. And at the same time, the possibility to litigate and to go to initiate review proceedings is much restricted in these cases, because we did have quite some litigation in the defense area, and I think in many cases it worked perfectly fine. But I guess the German legislator, the German government also wants to turn back time here. Now, what's the general context of this law on the acceleration of procurement for the Bundeswehr, for the federal armed forces? Of course, after the war started in Ukraine, our Chancellor, the German Chancellor Scholz, announced a Zeitenwende, so a historical turning point for Germany with respect to many things. And part of that was the setting up of a special fund for military equipment. So the special fund amounted to 100 billion euros. Which is, I guess, quite significant, at least in terms of German standards. And of course, now the problem was we had the money. How do we spend it? And procurement procedures do take a long time in Germany. And however, there was never a very clear analysis why they take so long. And at least in my perspective, the problem is not public procurement law or legal protection. It's different reasons, but these are probably the least reasons. Nevertheless, our politicians have a different perspective on that, and they thought that by basically getting rid of public procurement law and legal protection, this may contribute to the acceleration. Now, the good thing for the Military of Defense was that there was a blueprint law. It was just enacted a couple of months before concerning LNG terminals, because as you all know, here in Europe and especially in Germany, we not only have a security crisis, we also have an energy crisis, and Germany does not have these LNG terminals. So there was a law enacted to enable procurement of these terminals and to make that much more quickly. So the Ministry of Defense took the momentum and basically copied and extended that law to the procurement of military equipment. So the politicians basically could present a quick fix for the solution, for the problem, I think in a record pace of 6 weeks, this law was enacted. Although I must admit, I have hardly seen any military procurements after that. So we were very quick with the money and with the law, but the process itself has not, at least to my knowledge, they have not really started so far. And on the next slide, I will talk about the main content of the law. The first point, I think it's also kind of it may not have a big practical relevance, but I think it is a paradigm shift. Because so far in German procurement law, there were no restrictions for third country bidders, except of course in the utilities area, but that was based on EU law. So there was no national legislation in Germany where an exclusion of third country bidders was possible. And now this basically changed in this law, and it is now possible to restrict access or to make it possible to just leave the procurement procedure for EU companies. And in my reading of the law, it is also possible to exclude, for example, US-based companies from these proceedings from these procedures under certain circumstances, because the GPA generally doesn't cover defense procurement. So it is possible to restrict the procedures to EU companies as a matter of national law. I think an important thing to notice. Also, already hinted at that at the beginning. Exemptions of public procurement law and the possibility to make direct awards. Usually these possibilities have to be narrowly interpreted. The law basically now makes it possible in some instances to extensively interpret these exemptions, making it easier for the Ministry of Defense to get out of public procurement law. And also, so far, I think we have a pretty balanced system with respect to legal protection, review proceedings in Germany. And now this system in this new context is disrupted and significantly restricted. There are a lot of partly far-reaching possibilities to make it much harder for bidders and for the courts to actually take a thorough look at a procurement. So I guess the rationale is to to extend the exemptions and then make it very difficult for anybody to check whether they're actually fulfilled. And finally, the last point, we have a strict obligation to divide contracts into lots, and of course we do that for small and medium-sized companies. And in the new context, these very strict rules are a lot less stricter, and there are various exceptions in this new law. And on the final slide, I just want to make probably not going to be able to talk about all these points here. There are a couple of issues that, in my view, are at least questionable from an EU law perspective. First of all, the German legislator offers, again, it has done so in the past, but again, it offers an interpretation of Article 346, which obviously it can't do because it's a matter of EU law. Only the European Court of Justice is competent to do that. But again, it's in the law, and it basically states and clarifies in the meaning as the German legislator said it, what actually an essential security interest is, and the legislator states that an interest, a national German interest, may also be an interest of another member state or the EU, which in my view is a little paradox, because Article 346 is an exemption from EU law, and how can you justify an exemption from EU law with the interests of the EU? That is, for me at least, hard to understand. And one final point I want to make is the possibility now to declare the possibility to declare illegal direct awards ineffective. That possibility it's now possible for the courts to go a different way, and instead of declaring it ineffective, to just render sanctions against whoever. I don't know. It doesn't say so in the law. I guess this possibility is foreseen in the relevant EU directives, but the law just says that the courts can render a sanction, and making it very unclear if it's a sanction against the contracting authority, which is the federal government, and the sanction is to be paid to the federal government. It would hardly be a true dissuasive sanction as provided for in the relevant directives. So, and there are a lot of other examples in this law. Unsurprisingly, I guess, taking into account that it only took 6 weeks to finish, that are very, very questionable from an EU law perspective. And just to conclude, I'm not sure whether this law will achieve its goal to accelerate procurement, but certainly we will have less competition and less transparency in German procurement in the next years. So I think it's not a very, very good development.
Thank you very much, Pascal. It's quite interesting. We have just a couple minutes left on the hour. We just want to ask some questions. The first one's for Michael. Michael, in terms of the defense buildup that we're seeing, do you think that the defense buildup will be uniform across Western and Central Europe?
Sorry, I would be surprised because clearly there's a different context as to what politically should be done. It's partly a political question, isn't it? And at its starkest, you've seen that one of the unexpected effects of the war is the breakdown in relations between the Polish and the Hungarian government, and the different enthusiasm for what's going on. But also, I suspect, also reflecting the investment and ability of the existing supply infrastructure to meet demand will affect things. It's clear that almost universally across Europe, there's been great concern that we don't have the resources to really meet the demands that are being made on supplies. The UK government has had to send out, there's a reference in some of the papers to the UK government having to take steps to really reassure industry to make sure that we're going to be able to replenish our stocks quickly enough. But not all countries will feel will have the same degree of confidence that they will be able to replenish stocks for their own needs while supplying external needs, whether it's Ukraine or some other. It isn't, and of course, it isn't just Ukraine. It's other frontline states who feel the need to be ready to defend against whether it's Iranian drones or whatever it is from one week to the next. But I mean, the bottom line of all of this is it's the unpredictable. I mean, I was just struck by a comment this morning, as you probably know. The UK Defence Minister, despite all that's going on, the UK Defence Minister rushed out of London yesterday unexpectedly to go to Washington. And when asked why, his number two said, because he has to have the sort of conversations that are beyond belief, really. The fact we are at a time when these sorts of conversations are necessary is staggering.
Thank you, Michael. So we only have time for one more question. This is actually for all of you. Most of you have spoken about derogations from EU rules under Article 346 on a member state level, on a national level. Let me flip that upside down. Do you, as Europeans, see a greater role for the European Commission, for the European Union, in shaping defense procurement in the coming years in the member states?
Well, I mean, I think it would be good, but I have my serious doubts. I think the focus, as we've heard from all the other participants, is always on national industry and to kind of go the different way. I think it would be good, but it will be a long way, at least from my perspective.
Mash, did you have a comment?
I'm quite skeptical. I don't expect the European Commission being actually able to overcome the, let's say, political needs resulting from just safety issues in this part of the world. So I'm afraid this will not happen. What can happen is the extension of the cooperation, not directly in the field of the military procurement in those hard assets, but in some other aspects of the let's say security broadly understood, cyber security, the infrastructure items, things like this. There is still plenty to be done in Europe, and this might be the role for the European Union, frankly speaking.
Okay, thank you very much. Okay, well, we've run out of time. I want to thank you all. Speaking as an American, someone out across the Atlantic, I've learned a tremendous amount, and we very, very much appreciate your participation. For our guests, for our participants online, we hope you can join us as well on November 9th. Again, you can register at publicprocurementinternational.com. Until then, thank you again, and have a very good day. Take care. Bye-bye.
Thank you. Thank you. Bye-bye.
Thank you.